together with you.
Let us give directions and we will proceed with these directions which my Lord that very much so to give. There must be order in every proceeding.
Who is starting? Is it Mr. Yes, proceed.
My Lord, my name is Ochiel, and it's a great privilege and honor for me to appear before you and to make the Deputy President's joint. Ochiel, that is my name. My Lord, allow me to begin with where my very good friend Mr. Somani stopped. I think he intended to cite to you paragraphs 209 and 210 of the Supreme Court decision. He stopped at 208. I believe that was a mistake. Because if you look at paragraph 209, this is what the Supreme Court has said this afternoon, that the fellows of the Constitution made it possible for litigants, like our client, the Deputy President, without exception, to appoint the courts for redress of fundamental rights and on issues concerning interpretation of the Constitution to determine whether any law or anything said to be done under the authority of the Constitution is constitutional. Paragraph 210, Supreme Court, this afternoon, the court says that this constitutional inquiry, the inquiry we're involved in, extends. The court, when conducting this inquiry, should bear in mind the unlimited reliefs contemplated under Article 23. Now that's sufficient to clear any doubts about your jurisdiction and to clear any doubts about your power to give conservatory orders. If there are any doubt, the court should now feel comfortable. Now, during the break, I inquired for my learned friend, Mr. Kenkol, a very good friend of mine, and I asked him, Dr. Kenkol, who is the governor of Meru County? He told me, Kawira Mwangaza. Then I asked him, by what authority?
Is he still submitting on points of law, my lord?
He went there.
By what authority? He told me, by a conservatory order. And so, my lord, this court can give conservatory orders against impeachment. The conservatory order we are speaking about, the one I was speaking to my colleague about, was given by this court not so far ago, on the 21st of August 2024, in petition P429 of 2024. Let me come to the other case, the Kisii governor's case. And Lord Justice Ogola, you are familiar with that case, you're not a stranger to it. Because at some point you gave directions indicating that you would not interfere with the conservatory orders in place, and that that matter would come before Justice Okoye, which is the decision my learned friend, another good friend, Mr. Nyamodi, spent a lot of time on. Lord, that case is different from this one on the issue of delay. Under Section 32 of the County Government Act, a vacancy in the office of Deputy Governor must be filled in 14 days. What did Purity Moraturera do? She filed her petition on 1st of April 2024. The Senate impeached Dr. Robert Moya on 14th of March 2024. So she was coming to court outside the 14 days. Lord, in this case, we have 74 days under the Constitution, Article 149(1). Those 74 days have history in the constitutional text. My Lord, if you look at page 233 of the CKRC final report, you find Kenyans speaking about, my Lord, the need to allow the transitional processes to be disputed. My Lord, the Constitution gives a lot of 14-day timelines, but in this case, it gives 74 days. And we submit that the purpose of that is to allow aggrieved parties to come before the court like we have. So, my lord, on the issue of delay, which is a distinguishing fact, which is why the court did not give Kawira conservatory orders, but gave Mwangaza conservatory orders, is that the 14-day period had expired when the petitioner went to court. Allow me to concur fully with two things that my learned friends, Mr. Nyamodi and my good friend, Mr. Somani, said, that conservatory orders are ready for the court because the court has a duty under Article 23 to fashion appropriate reliefs. Conservatory orders, as they said, help the court to preserve a matter. And the matter to be preserved here is an impeachment both of the National Assembly and the Senate, and the subsequent nomination of Kithure Kindiki to the office of Deputy Governor. And again, unlike Mora, he is yet to take oath here. So the subject matter before the court is still live, and you can and need to preserve it. Lord, on the nature of conservatory orders, I agree fully with the submissions of the Attorney General. The case they cite, TSS spinning, helps the petition more than it helps the respondent. Because in TSS spinning, the court says that conservatory orders as tools for preservation of the subject matter hold the subject matter in situ. They maintain the situation of the subject matter before the mischief crept in. The mischief crept in here when Wendy Mutuse filed his motion. So the conservatory order preserves that state of affairs. It takes us to the point before the mischief crept in. More mischief will creep in if, despite this litigation, Kithure Kindiki is sworn into office. Other cases we agree with, cited by the National Assembly's Gitale Industries, helps the DP on the point that conservatory orders are tools for preservation of a particular state of affairs. A particular state of affairs, which so far you preserved, is that our client is a deputy president of the Republic of Kenya. We ask you to sustain the conservatory orders. My Lord, County Assembly of Embu, argued by the Supreme Court, is distinguishable. In that case, the Attorney General told the Supreme Court that if a vacancy occurs mid-term in the office of Deputy Governor, then that vacancy would remain to the end of the term. The vacancy, paragraph 28, County Assembly of Embu, the Attorney General told the Supreme Court would remain to the end of the term, it would remain unfilled. That time, we had not yet amended Section 32, Capital B of the County Governments Act. It was amended in reaction to this Supreme Court case. And so the Supreme Court, to that suggestion by the Attorney General, says that no, we cannot have an indefinite vacancy in such a vital office. That case is distinguishable.